Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello and welcome to Hull on Estates. You're listening to episode number 688. I'm Stuart Clark.
And I'm James Macfarlane.
Hello, James. Good to see you here.
Yeah, good to see you too. Thanks for having me on.
No, I'm excited for this podcast topic we have today. This is a topic that's kind of been bouncing around my brain a bit the last couple weeks and months because I at least in my own perspective, I've kind of noticed a recent upswing in cases that have dealt with this. And I think it's a new trend. It may not be. Someone out there can correct me if this has been around for decades and I'm just late to the party. But the basic topic is this. And I blogged about this recently, so make sure the blog is posted as kind of part of our chat today. But it's the concept of using estate freezes as a way of imposing a unilateral marriage contract on someone who's about to get married, and the potential kind of interplay between estate freezes and family law from a trust perspective, which is kind of how we come into this. And I think it's interesting to talk about because it kind of, it's an excellent way of kind of walking through the legal principles that are kind of at play both in estate freezes and I guess equalization, for lack of a better word, as well. And then also kind of talk about there's could be some very, real world implications for people who have this, scenario happen to them. So I guess kind of a good starting off point for me to kind of start this podcast off will be to talk about what the concept of an estate freeze is, right? And that people... the estate freeze itself is a very legitimate tax planning tool, which has been around for a while now. And the basic concept is this. So, we're not tax lawyers. This is not tax advice. But, so if you want to do an estate freeze, go talk to a tax lawyer who can help you through it. But the basic concept of an estate freeze kind of plays with the idea of the deemed disposition on death. So, roughly speaking, the Income Tax Act deems that every asset you own, you sell, in effect, your deemed disposition, the second that you die, and any capital gains that is owed on that asset before then. So if you bought, painting that was worth $100,000 in your lifetime, and then by the time you die, that painting is worth $200,000, there's a $100,000 gain in there. Well, even though you may want that painting to stay part of your estate to go to your kid, you have a deemed disposition of that asset on death, and you owe capital gains from, date of acquisition through to date of death. Now, the estate freeze, because, some clever lawyer or accountant out there thought up this concept, is a way to help minimize that tax burden. And in effect, you do it this way. Now, this is the tool that's often only done by someone who has so much, assets they don't need anymore because, in effect, you're giving away future growth on the assets. But basically what you do is, so say you are, the rich, owner of Company A, and Company A right now is worth $100 million. Well, you create a new holding company and you have two classes of shares, one of which you kind of assign the current value of the company. So $100 million, is worth, this company is worth it. Those are going to assign to first class of shares. And then the growth on those shares are attributed to another class of shares. And you give those shares away to someone or something else, typically a family trust, because you want to have some element of control still over them. But basically you are giving the growth away. So you have a frozen value of your assets, $100 million, and the future growth on that company is no longer attributed to you. It's attributed to the shares, which are likely owned by a family trust. So as a result, if and when you pass away, the deemed disposition doesn't go. So say when you die, that company is now worth $200 million. Well, because you froze the value of your shares at $100 million and gave the future growth away to someone or something else, that deemed disposition is now only at $100 million versus $200 million, and you've effectively saved yourself that tax burden. That is a gross oversimplification of estate freezes. I'm sure there are tax lawyers out there who are yelling at their phone or computer or you're listening right now. But that's the basic concept. You're freezing, it's in the name. You're freezing the value right now, and you're giving away the growth to someone or something else. Legitimate tax planning tool has been around for a while, and unless the legislation changes, will continue to be around for a while. But what's new, at least from what I'm seeing, is the use of that very legitimate tax planning tool as a way to potentially insulate someone who's usually a high net worth individual from potential marriage, equalization claims on the breakdown of your marriage. Maybe, James, you can kind of pick up there and talk about what we're kind of getting at.
Yeah, thanks so much, Stuart, for that explanation. So I discussed estate freezes mainly for tax planning scenarios, but we're starting to see some unintended consequences in the family law realm, specifically with respect to the equalization of net family property upon separation. So just a very quick refresher in terms of net family property equalization. First step involves valuing each spouse's assets on the date of the marriage and the date of the separation. And then the second step involves determining how much of a gain there was for each individual between these two valuation dates, and then calculating an equalization payments going from one spouse to the other. So how does an estate freeze fit into this picture? Well, let's say there's one spouse who does an estate freeze on all their assets right before they get married. Then that spouse, upon separation, could be seen as having no gain in their net family property technically over the course of the marriage, meaning that they might not owe any equalization payments. So just to kind of illustrate how this might play out in reality, let's go through a quick hypothetical. So in this hypothetical, let's say you have one person who has a net worth of $1 billion, and they're just about to get married to another person who only has a net worth of $1,000. There's no marriage contract, but on the day before they get married, the billionaire decides to implement an estate freeze on all of his assets without letting their soon-to-be spouse know. And the estate freeze thereby attributes any future growth in the billionaire's assets to a family trust for, let's say, the benefit of the billionaire's children from a previous relationship. So let's say they get married, live comfortably for a while, and then they separate and file for divorce after 10 years. Then let's say over the course of the marriage, the billionaire had actually redeemed a few $100 million worth of the shares he had. So that's his net worth, because the estate freeze or net family property was actually now less than it was on the date of the marriage, even though in reality you have the family trust that was accumulating a few $100 million worth of value during the 10-year marriage. Then let's say on the flip side, the situation with the other spouse who only had $1,000 at the date of the marriage, they had a gain because they didn't do an estate freeze. Now they're actually worth $2,000. So in this situation, just looking at it strictly, you might have a situation where the less wealthy spouse, because they technically had a gain, might have to actually pay the billionaire an equalization payment just because of the fact that the billionaire did the estate freeze. So this is a situation which, to my understanding, is relatively untested in terms of Ontario courts. And it's obviously the kind of scenario which could very clearly lead to litigation. And as it's a relatively new trend, and it hasn't been addressed, there's a few possible ways that a court might address it. And Stuart, I know that you had some thoughts just on how that might play out.
Thank you, James. Yeah, no, that's exactly it, right? People can kind of see, just from these examples, the very real world implications that these kind of cases could have, where you institute a freeze, the day before you get married. You can have people who, on paper, freeze aside, have grossly different assets, a billionaire and someone who's worth a few $1,000s. But because of this legitimate tax planning tool that exists and has been allowed to happen for years now, they can basically make it so they never can have a higher worth on date of separation than they did on date of marriage, and can insulate themselves from any hypothetical claims, notwithstanding the fact that, they're still very, very rich, and that growth still happened. They just spun off the growth to someone or something else like the family trust. So, of course, that makes you go, well, gee, that doesn't seem, pretty fair, at least, from my objective standpoint, staying at the sidelines here, that someone can, without telling their soon-to-be spouse, implement this tax plan that could have such huge implications from down the road. Are there ways to potentially pick at it, or how would the court likely, consider this scenario being put to them? And as James said, at least to my knowledge, this specific issue where the estate freeze is implemented prior to marriage, with the likely goal of defeating future equalization claims, has not itself been considered by the court. But the court has considered these kind of, transfers from what, one spouse transferring away part of their assets or even instituting an estate freeze as part of their marriage on, equalization. So we can kind of have a little bit of idea of how the court may or may not react to this. And the starting point is Stone and Stone, which was a case from 2001, Ontario Court of Appeal, and it dealt with the concept of the Fraudulent Conveyances Act. This is not a podcast about the Fraudulent Conveyances Act, so I won't get into too much detail about it. But basically, the Fraudulent Conveyances Act is, as the act is, as it describes itself, it is a way to pull back conveyances which are fraudulent, i.e., someone sending assets away. If you're about to declare bankruptcy, you send all your assets away and then declare bankruptcy to, shield those assets from the bankruptcy. Well, using the Fraudulent Conveyances Act, you can, in theory, try to pull those assets back into, the person's property and have claims against them. Well, Stone and Stone, for the first time, at least to my knowledge, considered the potential applicability of the Fraudulent Conveyances Act as between married spouses. And in that scenario, a terminally ill husband transferred a significant portion of his assets away right before he died to his kids from a prior relationship, and it was found that he did so for the express purpose of defeating the potential equalization claims of his still married spouse when he was about to die. The wife applied to the court, tried to say, well, hey, look, that's a fraudulent conveyance. He tried to get those assets out and away from me and my equalization claims. That should be undone. I want those pulled back and available for my equalization. And the Court of Appeal in Stone confirmed that spouses can be elevated to the creditor status as required by the Fraudulent Conveyances Act, and it's because of the equalization, right? So basically, if the equalization is imminent, a spouse can be elevated to the status of creditor, and if one spouse transfers assets away, then in theory, the other spouse can, using their status as creditor under Fraudulent Conveyance Act, say, hey, wait a second, give me that back. So you say, oh, okay, well, maybe Stone and Stone then would mean that in our, scenario where someone does the estate freeze right prior to marriage, could that other spouse say, well, I'm a creditor and I want to pull that estate freeze asset back in for equalization? And the answer is, well, maybe not. And the maybe not comes from a case called Reisman, which is a 2014 decision from the Court of Appeal, where someone then tried to apply Stone. So spouses, similar situation, two married spouses, one spouse in 1998 implements an estate freeze, sends off the future growth to, away from themselves. And then several years later, I think it was, so it's 1998 was the estate freeze, 2006 was the date of separation. The other spouse tried to argue fraudulent conveyance, Stone and Stone. I want to pull that estate freeze, asset back. And the court said, well, no. I mean, yes, a spouse can be elevated to creditor if, equalization and divorce appears imminent. But here we're talking 1998 to 2006. When the estate freeze was done in 1998, it was not done to defeat your claim as a creditor. It was done for legitimate tax planning reasons. And we're not going to say that spouses are always in that creditor-debtor relationship. So therefore, you, Reisman, cannot use Stone and Stone to undo the estate freeze, and the estate freeze is legitimate, which means you can't go after those growth in assets. So if we look at Reisman then and Stone and apply it to our kind of scenario, the immediate kind of thought pattern is, well, wait a second. If Reisman during marriage said, well, you're not yet at creditor relation because divorce isn't imminent, separation isn't imminent. Well, if someone did it before you were even married, does that mean that, well, it's even less likely the court would apply the Stone and Stone fraudulent conveyance? And the answer, of course, is, well, maybe, probably, we don't know, but at least raises question marks about whether or not Stone and Stone could be available to the scenario, and if that's the case, if the Fraudulent Conveyances Act is available at all as well. Now, there are other options that could be available. You could try to argue sham trusts, or that the trust itself should be undone for any other reasons, lack of capacity, lack of free certainties, whatever it is you're trying to argue, but you're into a much bigger lawsuit than just the Fraudulent Conveyances Act. So it's at least, at this point, a question mark on what the court's going to do with this scenario.
Yeah, thanks, Stuart. I think that's a really good summary given the uncertainty of kind of our best guesses for how a court may address this scenario. And just on that point of the uncertainty with the courts, I'm kind of thinking about, the regularity that we might kind of see this strategy popping up soon. So do you think that because there's so much uncertainty in the courts that it might cause a bit of a sense of hesitancy to try something like this just because there's no certainty that it will work? Or do you think it might have the opposite effect where like it hasn't been shot down yet, so people might be a bit more willing to kind of test the waters?
Yeah, I mean, obviously, our guess is just that, a guess. But, from kind of a first principle standpoint, I mean, estate freezes typically are only done by people with, significant net worth, because you're giving away such a significant part of your assets, i.e. any future growth, that you have to have enough already to live off of for the rest of your life and think to be comfortable that you wouldn't care about giving away that future growth. So you're already in a subset of people, which is more limited. Would those people take a chance? I mean, maybe, of course. I mean, it also assumes someone that they won't enter into a marriage contract. So it's someone who has enough money that they can live off of the rest of their life and not care about the growth. And it's a scenario where someone either doesn't want to, or the other side is refusing to enter into a marriage contract. So, I mean, if that's your circumstances, I can see people saying, well, what's the worst that can happen? Let's try it. Of course, there's a lot of risk with that from, if this is the only strategy you're doing, and ultimately the court says it's not a good strategy, well, that's a lot of risk to you, because now you've put your future growth on the line for equalization purposes, which makes you probably want to go back to the original, kind contract kind of scenario, prenup, all those kind of things. But the answer is, of course, anyone who's in a scenario like this is going to want to talk to their family law lawyer, kind of at length, and make sure that they understand the risks associated with this strategy, because, as you said, it is still a question mark. So the court does, we can't tell anyone, well, yeah, that's definitely going to work in the future, because we just don't know. We can give our best guess based off of cases like Stone and Reisman, but we don't know, right? And I've talked to other people, and I know that this strategy makes people get their backs up, and people don't like it because it just feels sneaky, and I don't know. Just people don't like the smell of it. It hasn't passed the smell test. So you can very easily see maybe some judge saying, you know what, I'm going to pull that backwards and allow you to have stone and stone like fraudulent conveyance. Or maybe the legislature steps in and changes, the statute to make it clear that this kind of scenario isn't okay. We don't know, right? It's a best guess at this point. And so as a result, it's kind of fraught with risk. But it hasn't been said the court hasn't said it doesn't work yet. So if you're kind of in a scenario where you're thinking, well, why not try it? I mean, maybe, right? Talk to your lawyers, talk to your family law lawyers, your tax planning lawyers, and see if it works, and go into it with your eyes open.
Yeah, I agree. And it really wouldn't surprise me just to see, a court or a legislature just kind of try to address the issue in the near future, especially if it's happening with a bit more regularity these days.
No, it's an interesting topic for sure, and kind of, as we said, one we can't give a definitive answer on, but one which kind of, it's interesting because we have seen it pop up a few times now, and it kind of, goes to show, lawyers using other strategies like tax planning strategies around estate freezes, and seeing how those can also give a different effect in family law and other matters. So it's kind of an interesting kind of, thought experiment, if nothing else, to kind of walk you through what an estate freeze does, but also, it could have some very real world implications for people if this is ultimately found to be a strategy that works.
Yeah, for sure. I guess we'll see.
Exactly. We will see. To be determined. But I think that brings us to the end of our podcast today. Again, I'm Stuart Clark.
And I'm Dan Macfarlane.
And until next time, you've been Hull Estates. Thank you very much.
Nice. Bye.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.